Constituent Assembly was formed, you have to place it before the Constituent Assembly.
But a wrong practice cannot result in
No, but
rewriting
sir,
the
we are talking
constitutional
of
provision.
we are talking
Yeah,
of a
indeed.
practice over what? Over
But
46 plus 18, 64 years.
64 years, after 64 years, you can repeal it. But with great respect, the same argument, it means that 373 can't be repealed. Then you continue with the practice.
Mr. Dave, if Article 370 works itself out and achieves its purpose once the Constituent Assembly for the state of Jammu and Kashmir has completed its task, then where was the occasion thereafter to issue constitutional orders post 1957?
Lord, that's for 371 to extend from time to time any amendments. Because there were many provisions of constitution which may not have been made applicable, or many laws which may not have been
But
applicable.
if you see the proviso to D refers to other provisions of the Constitution, which will apply subject to such modifications. Then matters which are referable to the IOA require only consultation.
Yes.
All other provisions of the Constitution require the require the concurrence. That's the second proviso.
Right.
Then the sub-article 2, clause 2 says, if the concurrence has been given before the Constituent Assembly has given its opinion, then it has to be placed before the Constituent Assembly for its opinion and for its concurrence. So your whole argument is that Article 370 has now worked itself out once the Constituent Assembly completed its task. But that would be belied at the least by constitutional practice, because even after 1957, there were orders which were issued, constitutional orders, progressively modifying the provisions of the Constitution in relation to the state of Jammu and Kashmir. Which means that, really speaking, Article 370 had continued to operate even thereafter. Therefore, it would not be correct to postulate that Article 370 achieves its life, and what is a temporary provision really assumes a state of permanence in the Indian constitutional fabric.
Lord, may I respect?
Because then there was no question of any constitutional orders being issued progressively from 1954 onwards or 1958 thereafter.
Refers to those decisions which were taken prior to its constitution. So to that limited extent, Constituent Assembly's approval was sought for. But subsequently, once the Constituent Assembly goes, whatever, my respectful.
But then where is the power to alter the Constitution at all? If your argument is right, then once the Constituent Assembly in 1956-57 takes its decision, there is no power to change any provision of the Constitution in relation to the state of Jammu and Kashmir.
I respectfully.
Which is contrary to what everyone accepted, that
373 is only in respect of continuation of 370 or not. Now, they agree, Constituent Assembly agrees. Once it agrees that it has to be continued, then it becomes some kind of a permanent decision. Please permit me to reread that 373. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative, or shall be operative only with such exceptions or modifications from such date as he may specify, provided that recommendation of Constituent Assembly of State in clause D shall be necessary before President issues such a notification. So, idea is that you have to decide as a Constituent Assembly whether you want this relationship to continue or not. So, they took that decision.
No, what I was trying to refer to is this. Clause 2 of Article 370 refers to a decision. It uses the expression decision. The proviso to clause 3 uses the expression recommendation. But the commonality between clause 2 of Article 370 and the proviso to 370(3) is some decision or action on the part of the Constituent Assembly. Just give me a minute. Both require some action on the part of the Constituent Assembly. Clause 2 requires a decision, and the proviso to clause 3 requires the recommendation. Now, according to you, once the Constituent Assembly completed its task in 1957, there was no question thereafter of invoking the proviso to clause 3. because then it's worked itself out, and the substantive part of clause 3 and article 370 becomes a permanent feature of the constitution. That's the submission. It's a submission worthy of consideration. Absolutely, we have to deal with the submission. I'm just trying to explore that submission. There is one internal inconsistency in accepting that submission, because if that submission is right, qua the proviso to clause 3, then the consequence would be that once the Constituent Assembly completed its task in 1957, there could be no amendment to the Constitution at all under clause 2 of Article 370, which is belied not merely by constitutional practice, but the acceptance by both the state of Jammu and Kashmir and the government of India that amendments were being made to the Constitution even after 1957 and until the disputed amendment of 2019.
Justice of Article 2.
Yes.
If the concurrence of government of state referred to in para 2 of subclause B of clause 1 or second proviso to subclause D of that clause be given before the Constituent Assembly is convened, it's purely limited.
It shall be placed before the Constitution.
Before. So, Lord, this is temporary within temporary. It is in respect of a situation where what the constitution now, a state is just come in, India is now become a republic, what constituent assembly is going to be convened soon, and if some decisions are taken to protect them, that government may do anything it wants to, state government, it may give its concurrence and its consultation, but it should be very clear whether people want it. So they said, if you have done it before, then place it before the Constitution.
But then would the power of the state government to grant its concurrence under the second proviso to clause D continue to operate once the Constituent Assembly completed its task in 1957?
Lord, what has happened is that government also has said in their affidavit, and
or would that power be exhausted once the Constituent?
All provisions of the Constitution. They have applied all provisions of Constitution by 1954. So really speaking, there is nothing left to be done. It is fully in operation now. 370 is fully in operation.
But then that is exactly.
We are talking about.
You're right, absolutely logically. But then why? How do we explain the fact that there were subsequent amendments to the Constitution by the constituent orders?
What?
Because, you know, the provisos to clause D refer to state government. Clause 2 refers to the Constituent Assembly, and clause 2 says if the consent of the government was taken before the Constituent Assembly was formed, you have to place it before the Constituent Assembly.
But a wrong practice cannot result in rewriting
we are talking of
provision.
We are talking of a practice over what? Over 46 plus 18, 64 years.
64 years, after 64 years you can repeal it. But with great respect, the same argument, it means that 373 can't be repealed, then you continue with the practice. It's nobody's case.
That's completely out. But otherwise, you will have to say.
But it is not petitioner's case that no longer amendments of Constitution can apply. That's not petitioner's case. Question is, what is it that was not supposed to have been agreed, a promise?
If the power under the proviso to clause 3 has exhausted itself, then equally the power under the two provisos to clause D has also exhausted itself. In which case, how do we explain the exercise of that power for 64 years?
Looking at 373 independently of 371. 372 has no application now. It lived its purpose. Because by its language, it says that if any decision was consultation or concurrence was given before we came into existence, you please come back to us and our decision will be final. That's ended now. So 372 is dead. That's how they wanted it, constitutional framers.
371 survived.
Life to it. Likewise, 373 was also given in a limited sense, and we can't give now life to it. 371 would survive for the purpose of continuing. Your lordships are right. I am not for a moment suggesting conceding on that position. But if it has continued as a practice, there is nothing wrong about continuing that practice. That means that Article 370 is alive to the extent of sub-Article 1. No difficulty about it. Question is, can you repeal it? can you withdraw it? Do you have power under 3?
But if 370 bracket 1 continues, it will be very difficult to say that 370 bracket 3 ceases to exist. The modality for exercise of the power under 370 bracket 3 is a different issue, which both Mr. Sibal and Mr. Subramaniam and Dr. Dhawan have addressed themselves to. But it would be, because there has to be a logical consistency between how you interpret
It is not. It is
clause 2 and its impact on clause 1 and the proviso to clause 3. It has to be in tandem. Either everything remains together or everything perishes together.
Then let everything perish together.
But if it did perish, what about the fact that it was applied from 1958 to 2018?
Power.
And there's no power to any of the COs.
What is our submission? My submission is that if you wanted to do it, you do it by constitutional amendment. You have no power. This is a relationship which has been continued for a long time, since 1947. And 371, therefore, continues, lordships are right that time and again, Government of India is, President has exercised powers and applied various provisions of laws and constitution from time to time. That's how they wanted it. That's how they wanted it. But, it's one thing to continue 371. And it's another to repeal 373. That's the difficulty. Nobody is not saying that presidential orders extending constitution are wrong or presidential order applying various laws are wrong. People of Jammu and Kashmir want Constitution of India. They want the laws to be applied. So that position, there is nothing wrong about it. But if you repeal it, then that limited power of the state to say that certain laws should be applied in certain manner, that special status, that's
You got the point. We'll move on.
Now just see.
Just 1 minute.